Bless you. Court calls the case, People versus Samira Smith.
Right out of the gate, this hearing already feels heavier than a routine courtroom appearance. You've got a young defendant, a public defender immediately talking about waived examinations, and a judge moving the process forward with almost mechanical efficiency. And if you're unfamiliar with how these hearings work, here's what's important. Waiving a preliminary examination is not the same thing as admitting guilt. It simply means the defense is choosing not to challenge probable cause at this stage, and instead moving the case directly toward circuit court. Usually that signals negotiations are happening behind the scenes. Translation? Both sides are already calculating risks, possible plea deals, sentencing exposure, and damage control. But notice the wording from defense counsel here. They mention no offers while also saying discussions are continuing. That's courtroom code 4. We don't have a deal yet, but everybody's still talking. And that uncertainty matters because when there's no agreement on the table, everything becomes unstable. Bond decisions, future charges, even whether the defendant stays in custody. This is also where viewers should pay attention to Judge Simpson's tone. He's calm, direct, and procedural. No theatrics yet, but judges often reveal a lot through restraint. He's letting the attorneys build the record first before he starts pressing harder on credibility, risk, and accountability. And trust me, that shift is coming.
Senior Assistant Public Defender representing Ms. Smith. Ms. Smith, would you please state your name?
Thank you.
Your Honor, at this time, Ms. Smith will be waiving the preliminary examination. She is aware that there are no offers, but we are continuing to discuss matters with the prosecutor and are also hoping to be able to work out a COTS agreement. Is that correct, ma'am?
All right. You understand that the preliminary examination is a proceeding where the people would have to show by probable cause that the offense was committed and that you committed it. You understand that, ma'am? And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Okay.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on the single. Ms. Gaines.
Your Honor, we acknowledge receipt of the information, waive its reading on the record. At this time, my client wishes to stand mute and have the court enter a not guilty plea.
Defendant having waived reading standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
August 12th at 1:30 before Judge Slay Monday.
August 12th, 2024, 1:30, Slay Monday.
Your Honor, may we address bond, please?
Right.
Your Honor, my client is a young woman. She's 20, just barely, just soon to be 21 in a few weeks. She has had a very challenging past few months. She has been, she recently had a son who is about a year old now. Her mother died unexpectedly in April of this year. And she has just had a very hard time financially, emotionally.
This is one of the most strategic moments of the entire hearing because the defense is no longer arguing facts. They're arguing humanity. Listen carefully to what's happening. The attorney is building a mitigation narrative piece by piece. Young age, recent motherhood, emotional instability, financial hardship, the unexpected death of her mother, prior legal trouble tied to personal collapse rather than danger. Every single detail is designed to answer one question for the judge. Is this someone who deserves another chance outside jail? And emotionally, it's compelling. A 20-year-old with a 1-year-old son, housing concerns, probation issues hanging over her head, and family members scrambling to help. That paints a chaotic picture. But here's the legal problem. Sympathy doesn't erase risk. Judges are balancing compassion against public safety, flight risk, probation violations, and repeat conduct. What makes this especially tense is that the defense keeps emphasizing stability. Section 8 housing, family support, childcare, while simultaneously admitting there are probation holds in another county. That contradiction immediately weakens the argument. Because from the court's perspective, if someone is already under supervision and still lands back in criminal court, credibility starts dropping fast. And here's the bigger question: should personal tragedy significantly reduce accountability in court, or does repeated legal trouble eventually outweigh sympathy? Let me know what you think, because this is where courtroom viewers are usually split right down the middle.
And it's manifested in many different ways, which includes having had some prior trouble in Oakland County before this, for which she is on probation. And we do believe that there are holds for Oakland County. We are asking, however, that the court consider giving her a bond that she could post. We're asking if the court will not consider a personal recognizance bond a $1,000 cash or surety bond, so that she can get to Oakland County and begin to resolve those matters as well. My client, as I said, has a 1-year-old son. At this time, her 85-year-old grandmother and her older sister are looking after him. But she does have Section 8, which is of great value to her and her son. And she would like to be able to keep Section 8, and an extensive amount of incarceration will impact her ability to do that.
Ms. Gaines, is she on probation on 9 offenses out of Oakland County?
I think it's 2 cases and between them, the 9 counts.
So
Yes, I'm saying correct. I just don't know the number of counts. I knew the number of cases.
Okay.
She does have family support. Her cousin, David John, is here in the courtroom. He indicated that her grandmother is trying to get here, and she would return to her address in Detroit, where she does have the voucher and would be able to take care of her son upon completion of the Oakland County matters, she hopes.
Did she violate on the Oakland County matters?
I do believe that there is a violation of probation, holds out of Oakland County as a result of this matter.
And there it is. That's the sentence that almost completely collapses the defense's bond argument. Up until this point, the attorney was trying to frame the defendant as overwhelmed but recoverable. Young mother, family support, housing assistance, emotional hardship. But probation violations change the judge's entire calculation instantly. Why? Because probation is already considered a second chance. Courts expect strict compliance once someone is under supervision. The moment Judge Simpson hears there are probation violation holds tied to this new situation, the conversation shifts from can she stabilize to can she be trusted to follow court orders at all. And that distinction is massive. Notice how quickly the judge cuts through the emotional framing after this revelation. He doesn't need a long speech. He doesn't need outrage. The denial comes fast and clean. Motion for bond reduction denied. That speed tells you a lot. In courtroom dynamics, when a judge rules immediately after hearing key information, it usually means their decision was effectively made the second that fact entered the record. And honestly, this is why experienced defense attorneys hate probation complications. They poison almost every future argument: bond, sentencing, credibility, rehabilitation, all of it. Also pay attention to how calm the courtroom remains despite the stakes being enormous. A young mother's freedom is being decided in real time, and the entire thing happens in under seconds. That's one of the harshest realities of criminal court. Life-changing decisions are often delivered with terrifying efficiency.
I don't necessarily need anything from the people unless you want to say something. Motion for bond reduction is denied. Bond will continue.
Thank you.
Received the agreement, and that form should have been tendered to Your Honor and to defense counsel.
I do have it. The form indicates that the defendant will be pleading guilty to child abuse 4th degree, punishable by up to 1 year, up to 5 years probation. And upon a successful plea to that charge, count 1 would be dismissed. There is no other agreement.
That is correct, Your Honor. Awesome. Good.
John Matthew Carlson.
Has he signed any advice or rights form, counsel?
Not to my knowledge, Your Honor. I can have him sign one right now.
Have the defendant sworn, please.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Sean Matthew Carlson.
Sir, it is this court's understanding that you're going to plead guilty to the charge of child abuse 4th degree. That is a misdemeanor punishable by up to 1 year incarceration and up to 5 years probation. Is there a maximum fine on that? Mr.
I
Reisman?
don't believe so. Let me check. 1 year or probation or up to
5 years, no maximum.
1 year
All
or
right.
jail or probation up to 5 years, no monetary.
Gotcha. All right, you understand that, sir?
Yes, sir.
All right. And you also understand that pleading guilty in this case, that I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right, understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Now the courtroom pivots into an entirely different kind of tension. We're no longer talking about bond or pretrial negotiations. We're watching a defendant formally surrender constitutional rights in real time. And this is one of the biggest misconceptions people have when watching plea hearings online. A guilty plea is not just saying, "I did it." It's the legal equivalent of shutting multiple doors permanently. Trial rights disappear, witness confrontation rights disappear, appeal opportunities narrow dramatically. The entire case effectively transforms from "can the prosecution prove this" into "what punishment follows." Judge Simpson is moving carefully here because courts have to establish that a plea is knowing, intelligent, and voluntary. That's why he keeps asking variations of the same questions. Were you threatened? Promised anything? Are you doing this freely? It might sound repetitive to casual viewers, but legally it's critical. One bad plea record can create appeal issues later. But there's another layer here that makes this hearing uncomfortable. The charge itself involves alleged child abuse. The emotional weight of those cases always changes the atmosphere instantly. And even though the defendant is calm and respectful, everybody in this courtroom understands the stakes become morally charged the second a child enters the conversation.
You had signed an advice of rights form today, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You'll see it on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
February 20th, 2024, at the location of 3137 Homestead Commons, Apartment 5, Ann Arbor City, Washtenaw County, State of Michigan. Did you have care or custody of a minor child?
Yes, Your Honor.
And what did you do with reference to that child?
I hit him in the arm with a closed fist.
All right. How old was the child?
10 years old at the time.
All right. And in doing so, you were doing something in excess of discipline?
Yes, Your Honor.
And that did, you would admit, cause physical harm to that child?
Yes, Your Honor.
I'm sorry, I didn't hear the initial factual basis for the plea.
Which part?
What did he say he did to the child?
He said he hit the child with a closed fist in the arm.
Okay, so if I could just read and make sure that this is correct for the record, the police report, Sean approached Anthony, the minor child, and punched him with a closed fist in his face, causing his head to snap against the wall. Is that correct, sir? Did that happen?
That's not what happened.
Okay, there's a big difference between the arm and the face.
This is the exact moment the plea hearing goes sideways. Up until now, the process was moving almost automatically. Rights explained, plea entered, factual basis established. Then suddenly the judge notices a major inconsistency between the defendant's statement and the police report. And this is not some tiny technical discrepancy. We're talking about the difference between hitting a child in the arm versus punching a child in the face hard enough for the head to snap back. That distinction matters enormously because judges rely on factual accuracy before accepting pleas. If the defendant minimizes conduct while the evidence suggests something significantly worse, the court has a problem. Judge Simpson immediately locks onto it, and honestly, you can feel the courtroom momentum change in real time. The judge's tone sharpens, defense counsel pivots, prosecutors stop coasting. Suddenly, everybody realizes this plea might fall apart. What makes this especially dramatic is that the defendant doesn't aggressively deny everything. Instead, he partially disputes details. That creates one of the messiest situations possible because now the court has competing narratives sitting inside the same plea hearing. This is also why defense attorneys sometimes prefer no contest pleas in sensitive cases. They avoid detailed admissions while still resolving the criminal charge.
Yes, Your Honor, I do believe it's a sufficient factual basis, however.
Was his nose bleeding when the police arrived, sir?
No,
Your Honor, would the court accept a no contest plea?
I don't know if the deal was continued upon him pleading guilty, but obviously we have two very, very different versions of what happened. I mean, either the child got hit in the face or the arm, and either the child was bleeding or he wasn't. Do this. Why don't I pass the matter? Counsel, why don't you talk to your client?
Yes, Your Honor.
And then I'll call you guys back up and let's see what we can do.
Thank you, Your Honor.
Thank you.
Indian officer again on behalf of the people, Your Honor.
Assistant Public Defender Dobby Lieb on behalf of Mr. Carlson, who stands to my right. Mr. Carlson, can you state your name, sir?
Sean Matthew Carlson.
Thank you for the court's patience, Your Honor. I have had additional discussions with Mr. Carlson as well as the conversation with the prosecutor. At this time, Mr. Carlson would like to enter a no contest plea.
Do I have? Oh,
I don't have an objection to that, Your Honor, and I have marked the police report as People's Exhibit 1, Ann Arbor Police Department, 24-7-818, and marked the injuries to the child and the relationship and the statement from the report. And ask that be admitted on the basis of.
any objection, counsel, to the court reviewing this report?
No objection, Your Honor.
That being 24-7-818 of the Ann Arbor Police Department.
And just like that, the strategy completely changes. After the earlier contradiction nearly derailed the hearing, both sides regrouped off the record, had additional conversations, and came back with a no contest plea instead of a straight guilty plea. That move is incredibly important. A no contest plea allows the defendant to accept conviction without fully admitting the factual allegations in open court. Why would that matter here? Two reasons were specifically mentioned: lack of memory and potential civil liability. That second part is huge, because when child injury allegations exist, criminal court is not the only danger. Civil lawsuits can follow, and direct admissions made during criminal hearings can later become devastating evidence elsewhere. Notice how procedural everything becomes once the revised agreement is reached. The police report gets marked as an exhibit. The court formally reviews it. The attorneys confirm no objections. Everybody is trying to create a cleaner legal pathway after the earlier factual confusion. But even though the plea survives, Judge Simpson clearly hasn't forgotten the inconsistency. You can already sense skepticism lingering beneath the surface. And this is one of the most fascinating realities of courtroom negotiations. Sometimes a case technically resolves, but trust never fully recovers.
Sir, the understanding is you wish to plead no contest?
Yes, Your Honor.
The basis for the no contest plea, counsel?
Lack of memory as well as potential civil liability.
All right. You understand that all the rights that I explained to you apply to a no contest plea?
Yes, Your Honor.
And everything is exactly the same. It's just that you are pleading no contest to the charge. You understand that?
Yes, Your Honor.
So to that charge, how do you plead?
No contest.
Upon review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of the defense counsel. Have I complied with the court?
Yes, the people are saying.
Defense is likewise satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be
August 30th at 9:30 before Judge Terry.
August 30th, 2004, 9:30 before Judge Perry.
Your Honor, you could just check on the form that it was a no contest plea, and the one other additional part that I believe was discussed between parties is there will not be a delayed or a deferred.
Is that correct?
That was discussed, Your Honor.
Well, was it agreed to?
In terms of my discussion with Ms. Willenbring, I believe I just asked if she would be offering one. I don't know that we necessarily agreed that we would not be seeking one. However, that may have been a discussion with the previous attorney.
What?
That may have been a discussion with the previous attorney on the case.
So just maybe a miscommunication. No, we're not offering one means that the reduction happens and we're not offering it and he's not seeking it.
And that is correct.
This exchange may sound procedural, but it actually reveals a very important behind-the-scenes courtroom battle. What they're discussing here is the possibility of a delayed or deferred resolution, essentially a mechanism that could sometimes help a defendant avoid certain long-term consequences if conditions are successfully completed. And listen to how messy the communication becomes for a moment. Defense counsel references prior discussions. The prosecutor pushes back immediately. The judge steps in to clarify the record. That confusion matters because judges hate ambiguity in plea agreements. Absolutely hate it. A plea deal has to be crystal clear. What's being offered, what's not being offered, what rights are waived, and what sentencing expectations exist. The second attorneys start saying things like, maybe there was a prior discussion, or there may have been a misunderstanding. The court has to slow everything down and pin the terms down precisely. And notice what ultimately gets confirmed. There will be no delayed or deferred arrangement, and the defendant understands that. That means this plea carries real consequences immediately. No hidden escape hatch. No quiet future dismissal mechanism waiting in the background. Then Judge Simpson circles right back to the issue that clearly continues bothering him most, the child's safety and the defendant's credibility. Even after the plea is resolved, he cannot let go of the contradiction about the injury.
So that is correct.
Yes, Your Honor.
He's not going to be seeking delayed or deferred.
That is correct.
You understand that, sir?
Yes, sir.
Thank you.
He's not around this child currently, is he? I mean, probably the worst thing is he told me something. I'm looking at the police report. He's telling me he hit him in the arm. There's a clear injury to his face. And
I know that CPS is involved. I would like to think that they remained involved, although I don't know that for certain.
He did complete a reunification process through CPS, Your Honor.
And so what's the status currently?
The child is residing with Mr. Carlson. Under the guidance of Child Protective Services.
What's that mean?
He completed a reunification process. My understanding is that they maintain some involvement.
Okay, so what is that involvement?
Just recently, my CPS social worker just closed the case out just early July. Since then, I've also been going through a lot of parenting classes, and I'm going through some other things through affiliates of with protective services, with like orchards and other.
Are you taking parenting classes now?
I completed mine. It was a 10-week course.
Pardon?
It was a 10-week course.
And so you're doing, there is nothing, the child is just with you.
Yes. And protective services thought it was still okay for him to be with me.
And I got some serious concerns with a man that can't realize that he didn't hit a child in the arm, but hit him in the face and coming before a court and telling me that. So you're lucky to be leaving today.
Fair enough.
You may leave.
Thank you.
This final stretch of the hearing is incredibly revealing because Judge Simpson stops focusing purely on legal procedure and starts evaluating character, accountability, and risk. The defendant explains he completed parenting classes, CPS involvement has ended, and reunification already occurred. On paper, that sounds positive. Those are exactly the kinds of rehabilitative steps courts usually want to hear. But the judge is still visibly troubled by one thing above all else: the continued minimization of the injury. And then comes the line that defines the entire hearing. Judge Simpson openly states he has serious concerns about a man who still insists he hit the child in the arm despite evidence of facial injury. That statement cuts deeper than a routine warning. It signals the judge believes the defendant still hasn't fully accepted responsibility. Yet despite those concerns, the defendant is allowed to leave. That balance is what makes courtroom hearings so complicated. The judge acknowledges rehabilitation efforts, CPS conclusions, and procedural compliance, while simultaneously expressing distrust and frustration. It's not a clean victory for anyone involved. From start to finish, this case became a collision between legal negotiation, factual inconsistency, rehabilitation claims, and child safety concerns. And Judge Simpson's rulings reflected that tension the entire way through. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.